instance without government interfering and saying, you can't say that, but we must take responsibility after the fact if what we have said turns out to be illegal, like libel, for example. So the difference is between prior restraint on you from saying anything that you want to say, and subsequent punishment, which may or may not be allowed by the First Amendment. Prior restraint would hardly ever be allowed by the First Amendment. So Neer established that proposition. The court has, this is not a relic of the distant past, this 1931 decision. It has served as an important precedent ever since in any attempt by government to get a prior restraint. As we'll see in a minute, that was certainly true with regard to the Pentagon Papers 40 years later. And it was true in Citizens United, decided 2 year ago, when the U.S. Supreme Court cited Neer for the proposition that what the federal government had done in the campaign finance law and how complex it was and how loaded the Federal Election Commission was with regulations, advisory opinions, rulings, and so on, so that people who wanted to make campaign contributions couldn't figure out whether they risked being prosecuted criminally for making a contribution because the laws were unclear and complex and so on. And the Supreme Court said that's akin to a prior restraint where you have to petition have to request from the Federal Election Commission a ruling about whether what you want to do violates the law before you speak in an election. And the court says, Deere versus Minnesota speaks to that issue and is still a live precedent. But as I say, there's no absolute rule against all prior restraints, and the door is still open if the government can make its case in an exceptional situation. The Neer case was the first time the court had ever considered a prior restraint, certainly not the last. It was almost the first time that the court threw out a law on First Amendment grounds, but it was beaten by 2 weeks by Stromberg versus California. Also, Chief Justice Charles Evans Hughes' opinion that was decided 2 weeks ago, 2 weeks before the Neer case. I'll just pause here for a moment of constitutional literacy. How would Neer have been decided in 1831, a century before, instead of 1931? Gina? Probably Neer would not win the case because the 14th Amendment wasn't there. And what effect does the 14th Amendment have on Neer?
Well, it prevents him from that so without the 14th Amendment, it only applies to the federal government, and the federal government has to do so that
Right. So in 1831, with no 14th Amendment, all there was the First Amendment, which applied only to the federal government. Congress shall make no law. So if Minnesota wanted to have this gag law, muzzling newspapers, treating them as nuisances, it was entirely free to do so as far as the federal Constitution was concerned, because the First Amendment didn't apply to the states. And then in 1868, with the adoption of the 14th Amendment, its due process clause forbidding states from depriving persons of life, liberty, or property, that incorporated the First Amendment rules and applied them to the states, so that Neer had a chance of winning. But it wasn't a slam dunk. It could have gone the way that Gitlow went. 14th Amendment applied First Amendment rules to the state of New York in Gitlow's case, but he lost the case because the court decided that Gitlow's subversive speech was not within the freedom of speech, as the court interpreted it at that time, protected by the First and 14th Amendments. So there's Neer. Then comes, let's fast forward 40 years from 1931 to 1971, when we're in the thick of the Vietnam War, a very unpopular war, huge demonstrations against it, young men your age fleeing to Canada and elsewhere to avoid the draft, complete disruption of American life, American politics, so on, highly controversial. And on Sunday, June the 13th of 1971, the New York Times came out with a front page story, it was a Sunday, came out with a front page story announcing that it had obtained access to a 47-volume treatise, study, I guess we'll call it a study, commissioned by the Department of Defense. Secretary of Defense Robert McNamara had secretly asked the Department of Defense to conduct a study of how did we get into this mess? How did the United States get drawn into fighting a war in Vietnam? And the Department of Defense had amassed all this material, interviewed people, gone over documents, diplomatic cables, and so on, and prepared this 47-volume report. And the New York Times got it somehow and came out with this front-page story on this Sunday in June, describing what was in the papers, announcing that they were going to conduct a series of reports on the Pentagon Papers, as they were called, and quoting from them. We clearly had these documents. Big surprise to the government. The government had no clue how the New York Times had acquired the Pentagon Papers, but was extremely alarmed because the papers were, of course, classified, top secret. The Department of Defense censors stamps had gone on each page of the Pentagon Papers, classified, top secret, under the classification system that we've had for many decades now, established by executive order, that the President of the United States authorizes executive branch officials to classify documents so that they're distribution is limited to people, only to people within the government who have to see them, and can't be disclosed to other people. Well, when the paper published sort of held its breath, whether the newspaper would publish was a big internal debate in the New York Times. They acquired the Pentagon Papers, we now know, the government didn't know then, from Daniel Ellsberg, who had been in the military, had been in Vietnam, was a brilliant young analyst who worked for the Department of Defense, who participated in the Pentagon study, who had become totally disaffected with the American war effort and wanted to stop it, and thought that one way to stop it is for the Pentagon Papers to be disclosed publicly. People ought to know about the duplicity, the lying done by American officials that resulted in getting us dragged into the Vietnam War and to get in deeper and deeper. And he attempted to get people in Congress and in the Senate, individuals who knew about the Pentagon Papers study, to publish it, and they wouldn't do it. So with some desperation, Ellsberg got in touch with the reporter for the New York Times, Neil Sheehan, who had been one of the Times reporters most involved in reporting on the war, and arranged to get Sheehan all 47 volumes of the Pentagon Papers. And the Times had the papers for a few months, and they were able to get their experts to look at them, to authenticate them, make sure that this was no hoax, that they were what they seemed to be, that they contained newsworthy information, and then to decide that they ought to be published. And the Times had been represented for many years by a New York law firm by the name of Lord, Day & Lord at the time, who advised the publisher of the New York Times that to publish the Pentagon Papers would be treason. And that sort of slowed things down at the Times, but to their everlasting credit, the publisher and the editor decided to go ahead and publish, whereupon the law firm, Lord, Day & Lord, walked out, quit representing the New York Times. And the Times got new counsel, Alexander Bickel, who was a professor at the Yale Law School and a renowned constitutional scholar, somewhat conservative, who agreed to represent the Times with regard to the Pentagon Papers. So the papers did get published. The Times internally knew that Daniel Ellsberg had leaked them to the newspaper. Nobody else knew that, and nobody in the government knew that. If you haven't seen it, I highly recommend you're watching the documentary that came out, I guess it's 2 years ago now, called The Most Dangerous Man in America, which is about Ellsberg and the leaking of the Pentagon Papers. He was called the most dangerous man in America by Henry Kissinger, who was President Nixon's national security advisor at the time. Well, what's the government going to do about this? The Attorney General of the United States at the time was John Mitchell, who later went to jail, convicted of the cover-up in the Watergate affair. But the Watergate affair hadn't happened yet in 1971, and John Mitchell was the Attorney General of the United States. On the Monday after the Sunday publication, the Times, still holding its breath, on Monday morning, published a second installment of its series on the Pentagon Papers. And then on that Monday afternoon, Monday evening, the Attorney General, John Mitchell, sent a telegram, which is how they communicated in those days. You ever seen a telegram? Ever received one? I doubt it. Anyway, that was a high-tech way of communicating in those days. And the telegram from John Mitchell addressed to Arthur Sulzberger, the president and publisher of the New York Times. Actually, it was misaddressed by the FBI. They had the wrong telex number, and the telegram was first sent to a fish company in Brooklyn, and then redirected to the New York Times. And Mitchell says to Sulzberger, I've been advised by the Secretary of Defense that the material published in the New York Times on June the 13th and 14th, captioned Key Texts from Pentagon Vietnam Study, contains information relating to the national defense of the United States and bears a top-secret classification. As such, Mitchell goes on, publication of this information is directly prohibited by the provisions of the Espionage Act, citing it. Moreover, further publication of information of this character will cause irreparable injury to the defense interests of the United States. Accordingly, I respectfully request that you publish no further information of this character and advise me that you've made arrangements for the return of these documents to the Department of Defense. Signed, John Mitchell, Attorney General of the United States. Well, the Times didn't do what Mitchell requested, determined to go ahead and continue to publish, not to return the materials to the government, and the government the next day filed suit against the New York Times in Federal District Court in Manhattan. Case ominously titled United States of America versus the New York Times. And the way cases are assigned to individual judges in big metropolitan districts is by random. When you decide to file a lawsuit, you take your complaint and summons and the other papers down to the clerk's office and hand them to the clerk, and the clerk stamps, you pay your filing fee, and the clerk stamps them filed, and then turns, in those days, they had a gadget that was sort of like a bingo wheel, and it had little dice-like things in there, hundreds of them, with the judge's initials from all the judges who were on the court, and the clerk would spin the bingo thing and reach in and pick out, you're assigned to Judge Smith. And that judge would be the one to decide the case. And that's the way they did it then. Nowadays it's all on computer and supposedly randomly you go in and file your case. The clerk turns to the computer and says, you're assigned, for example, the Proposition 8 case in San Francisco was randomly assigned to Chief Judge Walker, Brian Walker. So there's no judge shopping within the court. Well, when the clerk in the federal courthouse in Manhattan spun the bingo wheel and pulled out the initials of the judge, he found that the case had been assigned to Judge Murray Gurfein, Gurfein, who had just been appointed to the federal bench by President Nixon, who was a Republican, and it was Judge Gurfein's first day on the job. His very first case was the Pentagon Papers case, which landed in his lap. And the government requested a temporary restraining order, a TRO, an emergency order, stopping the New York Times from publishing the Pentagon Papers, lest publication cause irreparable harm to the defense interests of the United States, as Mitchell had warned the Times. Judge Gurfein granted the TRO, but set the case on a Tuesday, but set the case for hearing on whether to grant a preliminary injunction for 2 days later, on Thursday. I think you know by now that a preliminary injunction is a court order that stops one party from doing something during the lawsuit, during the pendency of the case, until the case can be finally determined. And at the end of the case, the court will decide whether there should be a permanent injunction. Never do this. The preliminary injunction applies while the case is pending. And Judge Gurfein heard argument, considered the evidence. The Department of Defense had presented all kinds of affidavits and argument that disclosure of the information contained within the 47 volumes of the Pentagon Papers, the disclosure of it would seriously harm our national security. It would disclose all kinds of information to our enemies, information that would embarrass our allies who had been involved in secret negotiations with us and so on, all kinds of deals being cut in return for their support in the Vietnam War, and that this would be disastrous to our national security. And Judge Gurfein heard the evidence, heard the argument by the New York Times, and declined to give the government its preliminary injunction, denied it. The same week, the Washington Post appeared with a front page Pentagon Papers story based on the Pentagon Papers. We now know that Ellsberg delivered the Pentagon Papers to the Post as well. In fact, the recipient of the Pentagon Papers there was Ben Bagdikian, who may be a familiar name to you. He was for many years dean of the journalism school at Berkeley. Back in Pentagon Paper days, he was a national editor of the Washington Post, and Ellsberg got in touch with him through an intermediary and requested that Bagdikian go up to Cambridge, Massachusetts, and meet Ellsberg to view the Pentagon Papers and decide whether to get them published and so on. Ellsberg was hiding out from the FBI at the time. He was in Cambridge, Mass. So Ben Bagdikian took the airplane shuttle up from Washington to Cambridge and met with Ellsberg in a seedy motel in Cambridge. And Ellsberg had set out the Pentagon Papers on one of the beds there. And Bagdikian thumbs through them and so on, and was obviously very interested. Can't decide on the spot whether they be published. Tells Ellsberg, I've got to take this to my people back in Washington, people who cover the Pentagon, cover the war and so on, have them authenticated. And Ellsberg says, fine. So they loaded up the Pentagon Papers in two big grocery bags. And Bagdikian took the shuttle back to Washington, and rather than check bags, he bought an extra seat on the airplane for the Pentagon Papers to ride with him back to Washington. And the Post, in a much more abbreviated inquiry than the Times had done, because the Times had already published, the Post came out with their story on the Pentagon Papers, and the government immediately sued the Post. And similar events occurred in the district court in Washington, and then when the Judge Gurfein in New York denied a preliminary injunction, the government immediately went upstairs in the federal building down Foley Square in New York. The Court of Appeals for the Second Circuit sits on the floors above the district court. And they took the elevator up, filed their appeal in the Court of Appeals, and the Court of Appeals stopped the Times from publishing until it could hear argument, which it set for 2 days later. The case was conducted with breathtaking speed. Similar events happened in Washington, although the judges ruled different ways. And both cases had gotten through the Court of Appeals by the weekend. And the emergency petitions for certiorari were filed with the U.S. Supreme Court. The Supreme Court granted certiorari right at the end of its term. It's the middle of June. They're almost done deciding all the cases accumulated during that term. And here comes the Pentagon Papers case. They know that it's a case of national significance. It's been all over the news for the past week. They know that it presents extremely important First Amendment issues. They granted certiorari. They set it for argument on a Saturday, the next few days later, after the cert petition had arrived at the court, and declared that the briefs be filed before the beginning of the court session on that Saturday. So the lawyers are up all night cranking out their briefs. When the court decided to hear argument, it set it for 2 hours of argument rather